See if I can press. Awesome. Okay. Hello, everyone. Thanks for being here. And for those who were able to join last month's session, it's good to see you again. My name is Sydney Swan again. I'm a co-parent coach and I own X's and Babies, where we have a podcast on co-parenting. And I'll go into that in a later slide. But I'm a Seattleite. I am also very much a father ally. And I really, really love this program. And I'm really glad to be back and, I'm glad that this exists, that programs like this exist because I know that it can be very challenging. That's probably an understatement for fathers going through the system of divorce and custody and such. So I'll stop there and I'll let Sarah introduce herself.
Hello, I'm Sarah Ellerson. I'm a family law attorney. I've been to Seattle Law School, graduated in 2012. Before becoming a lawyer, I was a legal assistant and a paralegal for a family law firm. I started my own practice about 2 years ago, and yeah.
Awesome, awesome, awesome. So we are here today to talk about collaborative divorce. This was a new topic to me a couple years ago, and I was just so in awe of the possibilities of um, limiting the amount of harm that can happen when couples decide to, transition and not be in a marriage together. And of course, I'm thinking about children a lot with my profession and knowing the outcomes, the better outcomes that there can be for children whose parents go through collaborative divorce is just um it's it makes me very happy. And so any chance that I get to bring lovely folks like Sarah around to help the community know about collaborative divorce, it's an honor. And so I want you all to, definitely take in all the information you can as it pertains to your own clients and patients, because I think this can be a really great tool for folks going through divorce who are looking for better outcomes and less emotional harm, if you will. Just a little bit about X's and Babies, which we partnered today with the Fatherhood Council to bring this to you. I started X's and Babies. I'm a co-parent myself. That's my son in the photo there and his father. And, we realized that there's a lot of opportunity to support folks and really shift the mindset of co-parenting to be one that's fulfilling and a mindset of teamwork. And so we aim to uplift and uplevel co-parents through podcasts. We have season 3 launching next month. We have certified coaching and workshops like this. And so please reach out if you want to partner and find ways to help communities co-parent peacefully. For today, we have a lot of goals, but we really want you to walk away today understanding what collaborative divorce is, what are the steps from start to finish of collaborative divorce, what are the differences between traditional divorce and collaborative divorce, and see, how this might be able to benefit either fathers and other clients of yours as a way to, again, try to mitigate the harm that can happen in these engagements, if you will. Just, level setting. We want you all to participate in dialogue. We'll have very clear times to contribute and come off mute or type in chat any responses. So I want everyone, of course, to be respectful. I don't have to tell you that, but just by saying, I also mean like being respectful to yourself too. If you need to go use the restroom or whatever it is, or if you need someone to speak up, or if you need something from us to be more comfortable in the space, please let us know. Please share. We'll learn from each other. And that's the best way we can get through this and continue to get the most out of these sessions. And then, of course, this is a judgment-free zone and be present, get the most out of this. If you got to turn your phone off, I know I have to. I have ADHD and I put that thing far away. And then let's have some fun, dare I say, and connect with each other. All right. So just to kick it off, I would love for you. In the chat to write some words that come to mind when it comes to divorce. And I'll keep an eye out there. But I just want you all to throw some things in the chat that comes to mind when you think of the word divorce. And I'll keep an eye out, but we'll still move along to the next slide. Yeah, I see change, loss, grief. Mm-hmm. two-family household, winners and losers, for sure. I see peace. That could be a great outcome too, for sure.
mean, a
Yeah.
lot of these are, yeah.
Money. That would be the part I'd hate the most about it. Um, Tug of war, panic, insecurity.
Insecurity.
Yeah. Control. That's a big one. Um, and now I know I won't spend too much time on this because I know we have a great group here, but I think it is worth just like making sure we're all on the same page of what divorce is. And there is like a legal element to it, right? It's the legal dissolution of a marriage. And when I looked up the like history or what have you, the etymology of the word divorce, it's really about two people turning away and parting, right? But if you're co-parenting, I'm always going to be talking from a co-parenting lens. But if you're co-parenting, you can't just turn away and walk away, right? You still got to come together in some way to co-parent. And so, even the word itself might not really serve some families. Now, I would love for people to come. Again, we want to orient ourselves around this idea of divorce before we jump into collaborative divorce, but feel free to come off mute. Like, what are some breakdowns that you've seen in the current divorce process? And of course, this audience, particularly for fathers, we'll spend like 5 minutes here.
I would see a breakdown in the way that the message is being interpreted, like a miscommunication or misinterpretation type deal.
Thank you, Charles.
Uh,
Sure.
just jump in to give my 2 cents on it. I've seen fathers being intentionally excluded. And when I say intentionally, I mean the big Fatherhood Council meeting in Tacoma just last go around. I was talking with women who worked in the custody court system, and they informed me that they've been having a problem with uh, um, there being a requirement of a pre-interview before meeting with the judge where they would interview the mother and then they'd interview the father. And they told me flat out that they would actively seek out to interview mothers, and then they would just mark couldn't find for the father without making any attempt to find the father at all. And when I asked, if you are catching these people in your office doing this, are you holding them accountable, whether it be, firing them because their willful refusal to do their job? Are you, turning them over to the police because they're actively robbing fathers of their rights? Uh, I was told, well, we're making them go through training again. So it's a crime without a punishment, apparently. And this is one of the speakers, who I think she was from Ohio, maybe. What she talked about on stage made it clear that in her state that's the same problem happening there as well. And then she gave some of the excuses given, like if a father happened to be in jail, and the women didn't want to, the women in the office there didn't want to make the drive, they would say that they would mark that they didn't feel safe going to the jail. And so they wouldn't have to. And so they would just mark couldn't find the father. And then I've talked to several fathers who went through the divorce proceedings. And when I asked them if they had that interview before ever meeting with the judge, and they said, what interview? Like they had no clue an interview was ever supposed to happen because nobody's telling us. I mean, so I've noticed that in the proceedings happening. That is a parent, like I view it as blatantly anti-father, on the best side.
Thanks, Zachary. Are there other folks that would like to share?
Thanks, Zachary. It's brutal.
Hello, my name's Tom McQueen. I went through the system as a father going through divorce. I seen the biased opinions when you enter the court as a father versus a mother, and the ideology that the mother is the best applicant for the children. I sat in a courtroom with the judge, not looking at the paperwork, but just looking at the circumstance. And he reamed me from one end to the other about being a father, leaving his family, and asking and only allowing so much money, which was the minimal amount, until he looked at the paperwork.
Mm,
Actually, I rose my hand and said, "Excuse me, Your Honor, the kids are coming with me."
mm,
He lowered his glasses and said, "What?" I said, "Yes, Your Honor. I'm not asking for child support. The only reason I'm asking for this money because the state says I have to have the minimum. These are my children. They are coming with me." But
mm,
what I'm really trying to reflect is the immediate biased opinion about the situation, as the man is always at fault. The father is the bad one. Without even looking at any kind of evidence, the initial case is revered as father negative, mother positive.
mm.
And that's just my practical take. Thank you.
Thank you for sharing that. That's really effed up, for lack of a better
Yeah.
word.
I would want to say one more thing too, because just like the gentleman Tom mentioned, I also went through the whole process, and it's been probably 16 years,
Mhm.
and it does create a lot of like emotional suppression, because you can't really express your feelings like we would like to,
Mhm.
because we don't want to come off as being defensive or being confrontational or all those other, adjectives that describe that. So I could just tell from the gentleman that was just speaking, I feel the same exact way he does, but we can't always express it.
Mhm. Yeah, I remember being in the court hallways waiting to support a friend who was doing child custody proceedings, and a Black father stormed out of one of the rooms saying, like, just yelling, like, she doesn't even take care of them. Like, how could you rule on this? Like, he was so mad, and I just wanted to, like, hold space for him, but obviously I didn't want to get in his way. He was very mad. But anyways, I said to say, just watching that and witnessing that, I just, yeah, it really it sucks. And I've heard lawyers and judges say, you don't even want me making decisions on your case. I only have 15 minutes to read it. And it's usually no one's happy with the outcome. And so to hear that from multiple judges, I'm like, okay, we got to do something else here, which is why I'm really excited about sharing collaborative divorce with folks. We'll take one more comment. Go for it.
All right, can you hear me?
Yeah.
All right, I'm kind of new to all this, and I guess I was just kind of joining in and listening and wondering if anybody I have three children, but my question is, anybody have disabilities here? Because I'm disabled and trying to be a co-parent. Wow, holy smokes! So that's why I'm here and just listening and seeing if how that affects everyone's situation and how that's what's the challenges of going through this process, because this is really new and it's just very scary. So anyways, that's about it. Sorry, thanks for calling on me.
Oh, don't apologize. Thank you for sharing that. If yeah, that is a unique experience. I'm like, oh, maybe there's something to explore more around that topic.
Yeah,
Um, so as we can see how it fits in, but for sure something I will noodle on.
yeah,
Um, awesome. Okay, thank you
yeah.
everyone. And I know that this could be opening up things for people. So again, take care of yourself, get some water, deep breaths, whatever you have to do, because this could be opening a lot of things for folks emotionally. All right. I do want to keep moving forward, and I apologize. Please feel free to put something in the chat, but I'm going to hand it over to Sarah.
Guys. So a couple of things I wanted to circle back on, which probably it's me kind of going off script, but will probably be sprinkled in my presentation at some point. But a couple of the words that I saw in the chat about divorce was divide, right? And I think that that is historically what a lot of people think. And I think that it's not that we're there, but I guess my goal as a practicing attorney is to help people figure out a way of restructuring their family, right? It's not necessarily dividing the family, but now we are still a family. We are still a unit, a village, whatever you want to call it. It's restructuring the roles and figuring out a way to come together is ideally what I think would be best for everyone. Now I get that that's not right for every case, and I get that sometimes things have occurred that prevent that from happening. But I would like that to be, at least from my standpoint, I try to tell clients like, look, this isn't necessarily your ex-husband, you're restructuring this person, or your ex-wife, right? I have a daughter, and when she knew I was an attorney from a while, but she didn't really understand what that meant. She was about 7 years old, and she was like, wait, you divorce people, you break up homes? And I was like, no, they come to me, right? She's got the sense of like, I go in and I just do what I do. And I was like, no. She's like, do my grandparents know what you do? Does God know what you do? I was like, no, honey. I was like, I make single people. She was not having it. She was very upset with me for a while. Once she realized what I do for work, right? And so I try to say, look, sometimes it is not great for parents to be in a romantic relationship anymore. Sometimes they are better off separate, and sometimes the children are as well, right? It's how we then restructure it and how we think about it and approaches we take. And that can then cause further damage, right? There's a reason why parents are separating, right? So I think a lot of this is focusing, you'll see the word divorce throughout our slides, but this isn't just about divorce, right? Like I've got several clients who were never married, right? And they're ending their relationship. I've got some clients who they met at a bar and had a child, right? And so there is a custody thing. And those are really interesting cases because they don't necessarily know each other that well, right? And now you want me to co-parent with you when I don't even really know you. And so when you see collaborative, it doesn't have to just be divorce, right? It can be in any of the senses where there's some things that need to be figured out. Some issues have arisen, right? Another thing that I saw in the chat was communication and miscommunication, right? And so I view part of my job is not only am I an attorney, but you should find attorneys that are also counselors, right? Like we're not therapists, so there's a difference. And I tell most of my clients, like, look, it's a really good time to get into therapy, religion, community, whatever it is, and lean on them because the attorney is not your therapist, right? But I am a counselor. Part of my job is to give you options. It's your job to then pick the option, right? And so to help counsel with communication. And often a lot of marriages, relationships are ending because of miscommunication, being misunderstood, lack of communication. And so one of the reasons why I really like collaborative divorce is it's pretty direct, right? And it helps the parties become better communicators with a team of people. And even when it's not the collaborative approach, for whatever reason, encouraging my clients to now more than ever, do you need to co-parent? Do you need to communicate with that other party if there is a child involved? Right? You're gonna have to get your communication skills up to par and not necessarily, I'll oftentimes take the high road, right? You saying, well, I'm just not going to communicate with them, just exchange the child. The child's 3, we don't know what time the child ate, had aspirin, whatever it is. You guys truly have to communicate like, hey, I'm noticing Billy doesn't like to do his math at my house. How are you doing at your house with math? Right? But if you don't have that trust in that relationship, that's going to come across as I can't tell her that Billy's struggling with my math at my house because she or he is going to use that against me, right? And so trust communication is huge, and better communication, I think, provides, where everybody's standing, right? You know what to expect. You're not waiting in the dark. I think it also is best for the child, because then there's 2 parents that are well aware of what's going on in each household, and with the kid at school or in sports or whatever it is. Last thing I wanted to hit on was judges, right? I don't disagree with you guys, and nor am I going to sugarcoat that. I think that the court, in my 12 years of being a lawyer, still has a little bit of a favoritism to mom. But I will say more recently that I've seen a shift, and I don't know if that's my case, right? This is anecdotal. This isn't data. There's been a huge turnover. A lot of the baby boomers, old cisgendered white males, are retiring off the bench, and the bench is becoming, at least in King County, way more diverse. And so I've seen better outcomes significantly for fathers in the last 3 to 5 years. And so I'm hoping that continues, but this is my plug for voting in local elections and how important local elections are, right? And here in Washington, judges can either be voted in or they can be appointed by judge, whoever the governor is. It was Inslee for a while. And so he would appoint people if there was an opening, right? But then when there's up for election, it's time to vote. And so voting, right? Like, yeah, national elections are important, but these judges are deciding if you get a speeding ticket, right? Criminal stuff, your family stuff, right? And so you want to make sure that who's on the bench are people that have your best interests at heart, right? And are going to listen to the law, are going to read what it is and vote fairly versus making judgments. And so that's my plug for why local elections are extremely important. Because that's the only way things are going to change. Yeah.
Can I add just a little bit to that?
Yeah.
We have been, as a council, working really hard over the last few years to try and get into the judges sort of training academy and make sure that fathers' voices get into their thought process and how they understand. And this is the first year that that's going to happen. So I'm really excited about bringing some fathers' voices in a formal way that helps judges and commissioners and other adjudicators understand the role of fathers in healthy families. Because I think it's also just part of the training that is missing. So get the right people elected and train them is a big goal of this council. So I'm so glad that you brought that up.
Yeah. And my last thing on this was emotions, right? And I do view that fathers, all fathers, but particularly fathers of color, right? Like women are allowed to be emotional. They're allowed to cry on the screen. They're allowed to get angry, and they do get a little bit more of a pass. And so I think that's something that our judicial officers need to be more aware of, right? It's the terminology that is used is different to me than it is with women, right? It's he was angry or mad versus he was emotional, right? Or sad or upset, frustrated, right? And so those are things that I think all practitioners need to watch out for in our terminology of things, and I'm by no means perfect at it. Okay, so going back to collaborative law. So collaborative law has been around for several years, but it's just now starting to get movement, particularly in Washington. So it's new. It's an approach that a lot of people haven't heard of. I think that there's a lot of myths around it. A lot of people think that it means everybody has to get along really well, which isn't necessarily true. There does have to be some baselines, which we'll get into, but it's a legal process that allows families to do it with a team, and in a very different approach than what I call litigation, right? So litigation for me is the overall court process. And it can be different, right? It doesn't necessarily mean that we're going to trial, but what under the umbrella of litigation is temporary hearings. Who's moving out of the house? Who gets temporary care of the kids? Who's paying temporary support, right? It can be arbitration. Are we taking depositions? Are we doing informal interrogatories? Are we getting a guardian ad litem involved to do an investigation or a parenting evaluator? And oftentimes, and then court, right? Everybody thinks, oh, litigation automatically means court. And no, it means all of those other things, right? And in your traditional litigation, there's not as much transparency. It can be longer. It can be more costly. And so I think that my job as an attorney, as you'll hear me say 1,000 times, is to give clients options. And I think a lot of people meet with a family law attorney, and family law attorneys who don't practice family law sometimes are not telling their clients, hey, there's this other option. And whether I practice collaborative law or not, here are your options, right? I think our jobs are to tell clients there's not just one approach to this. There are possible options. It's then the client's job to pick the route. And collaborative law is one of the approaches that puts clients in the front seat. Sydney, will you go to the next slide? So oftentimes, like these are stats from different areas and not necessarily Washington per se. Most cases, I would say most family law cases in Washington settle in 9 months, whether it's collaborative or not. In King County specifically, you get a case schedule that's 11 months out with a trial date 11 months away. I'd say most cases, but not all, settle somewhere between 6 to 9 months, whether it's collaborative or not. It's a different path. right? And to me, the collaborative process is typically a healthier path. So when we talk about emotions, right? And depression, all those things. It again isn't all roses and butterflies, but it's direct. Everybody knows and has ideas of what is expected of them and what's going on. And so it's a more direct communication process. Most cases, whether collaborative or not, settle without going to court. In Washington state, only about 1% of family law cases actually go to trial. It doesn't mean that there wasn't hearings, doesn't mean there wasn't a lot of browbeating or other things going on leading up to a trial. Doesn't mean there wasn't other court appearances, right? And then most collaborative law cases end in a settlement agreement, which is important. Yeah. So when I talk about giving options, right, these are what I show a lot of my clients, most of my clients during our first meeting of, hey, there's different options, right? It's not cookie cutter, nor should it be. What we all know kind of is this last one court, right? If I go all the way to my right, so the judge is in the driver's seat, right? And we've got the parties are all the way in the back, right? You've got your attorneys and maybe your team up front and everybody else is behind you, right? You're not in the driver's seat. And there's lots of layers to that. And if you look down below, the cost is much higher. Your control and involvement is lower. And so if we go all the way to the other end, go back to the kitchen table approach, right? Some clients are able to sit at a kitchen table. I say, hey, kitchen table is fine if you guys get along really well, but there's also Starbucks, right? Or a coffee shop, because then it's not somebody's home base. People are less likely to raise voices. It's more of a neutral space versus I'm going to get up and go, I'm going to walk to my bedroom or please get out of my house, right? You're at a neutral location. And so although it says kitchen table, if I didn't make this graph, I'd probably scratch out and put cafe or something of that nature, park, something where the kids aren't there as well. And then you guys can confer with attorneys, right? You've got that line below where you can meet with each other and then like, hey, attorney, here's what we're thinking. Am I on the right path? Or, hey, they offered me this. I don't really feel like it's fair. I kind of want to do that. What do you think? Right. But it really puts the two of you in the driver's seat. The next one is mediation with a third party neutral. And so with collaborative law, you can do where you've got this third party neutral in the middle and you guys break it up into sessions, right? If I go back over to settlement conference for a second, settlement conference also can be the word mediation. Before anybody goes to trial in Washington state, you have to try to do a settlement conference, also known as a mediation. And if we go to the settlement conference one, right, we've got that settlement conference person in the middle, but do you see that blue line in between them? It's what I call shuttle diplomacy. And so they're sending offers back and forth between two rooms. It used to be two conference rooms. Now it's two Zoom rooms. But you and the other party are not communicating, right? There's a wall there. And so and that is effective. It's not necessarily healing. And it also has cost is high, your involvement, your control is lower. What I like better is this other, and that is usually an 8-hour long mediation. So everybody's there trying to figure out who's getting the house, dividing up assets, dividing up debts, talking about the kids, talking about support. 8 hours being on a Zoom or in a conference room, to me, is not the right way. And some of them go longer than I usually call it at like 7 o'clock at night because I don't feel comfortable with my client signing something. But that is the more traditional, what most people experience is these full day where you're expected to sign a settlement, deciding the rest of your life at the end of that 7 hours, 8 hours, whatever it is, you're exhausted, right? The mediation approach, going back over to the other side, those are usually broken up into 2-hour sessions with topics and agendas, similar to collaborative law, which we'll get to in the middle. But it's, hey, today we're going to focus on kids. Next session, and between now and next session, which are usually like, we try to schedule them 2 to 3 weeks apart, depending on everybody's schedule, but they're 2 hours, right? And so you're not feeling beat down after 8 hours. But some people don't want to keep coming back, right? So again, different approaches for different people. And then we have collaborative mediation where you have the mediator in the room, the attorneys are in the room, right? And we're all in the same room versus doing shuttle diplomacy back and forth. And that's more interest-based. And then there's the collaborative practice, which we're going to get into, right? It's a team with everybody at the table. Again, as you see, the collaborative law is in the middle. It's not necessarily much lower of a cost. It's often lower than trial for sure. But it's putting you, the parties in the driver's seat with support around them.
Awesome. If you have any questions, please put them in the chat, and we will definitely circle back and get
Yeah,
to
I see while you're switching slides,
Oh, are there
like,
some?
hey, I did an 8-hour mediation that cost $6,500. Yeah. And so the other mediations, right? These other two aren't necessarily less expensive. You're breaking it up. So it still could be the same, could be a little bit lower of a cost, but could be the same cost, right? But imagine being there for 8 hours and still not reaching a settlement. Spending $6,500 and still not reaching a settlement, right? Or somebody just being like, look, my brain hurts. I don't want to sign this today. I've been here for 8 hours. And so are you signing because you want to be done and you're exhausted? Or are you signing because you actually understand and agree with what the approach is? And so, in my opinion, breaking it up into sessions is better. At least that's how I am, right? But I get that everybody's different. It doesn't necessarily mean that it's going to be lower cost, right? It could be. Maybe you guys don't need 4 sessions. Maybe you only need 3, right? But everybody's going to be different.
Right. Awesome.
I'm ready for the next slide.
Yeah.
So some high level overview of like litigation, right? Litigation again can mean anything that is you both filed, somebody filed, the other person's responding, you may have hearings, you may not, but it's not collaborative. And we'll get into why collaborative law is more different. Litigation is usually more adversarial, not always, but oftentimes is. You can't be as transparent or open because people can use what you say against you, versus in collaborative, it's really encouraged to be open and honest and transparent and work on communication, right? And so this is just a table to kind of let you guys see the differences.
Can I share one thing?
Yeah.
I don't know if we said this yet, but my favorite part of collaborative divorce is step 1, from my understanding, is agreeing and signing that you won't go to court. And we'll go into that a little bit more in a few slides, but that, for me, I haven't had to go to court. No. However, I know I would be reactive and fearful and probably not be my best self if I knew I had to go to court, even if none of the information before or part of my relationship would suggest that I needed to be that way. But just the idea of court, being a Black person in court, that just terrifies me. And so I love that part of collaborative divorce.
I gotta say too, I've never heard of that part of it, but it seems like that's like an act of good faith on both sides.
Yeah, and we'll get deeper into that. There's a lot of, I think that's a huge component of it. And a lot of people don't understand that or aren't explained that, right? When you meet with an attorney, and I'm trying not to beat up on attorneys too much because I am one. And I was that attorney 5 years ago. I was like, oh, I've heard of collaborative law, but I wasn't really telling clients that's an option, right? Because I was like, oh, you contacted me, so I'm a litigator, right? Versus saying, hey, at the time I wasn't doing collaborative law, right? And so it's like, hey, here's some other options, and I might not be able to talk in depth about it because I don't know, but here are some options. And what I do say in all my consults is like, look, and we'll get into this, meet with 1 or 2 attorneys before you decide who to hire for a variety of reasons, right? And potentially meet with a collaborative law attorney, even if you're not sure your case is going to go that way, because you can still bring some of those tools into the traditional litigation if it can't be truly collaborative law, but not all the tools can come in because they are 2 separate boxes. Sydney, I'm ready for you when you're ready.
Right.
Okay, so steps to collaborative law. So the first step is that both parties have to hire a collaborative law trained attorney. It doesn't have to be a collaborative law trained attorney, but oftentimes if they're not, then it could fall apart. So I had to do like a 40-hour mediation training, and then I had to do another 8-hour collaborative training. So I had several hours of training because it is unpackaging my brain of litigation where I'm fighting for my client, right? I'm advocating for my client. And sometimes my client wants to make an offer that I think sometimes makes them vulnerable. And I have to explain to them like, look, if you're vulnerable here, it could come back to bite you, right? And so sometimes it's not healthy always for the kids or the parties because they have to understand the risks of being vulnerable in a traditional sense, right? And so we have philosophies and principles that are instilled in us. It is a different frame of thinking. We have to be able to help clients communicate, be creative in resolving conflict, which as a litigator, I think a lot of attorneys are as well. There's a teamwork approach versus in a lot of it, you'll hear me say like, oh, opposing counsel, opposing party. There is no opposing in collaborative law. It's the team, the other party, the other party's attorney versus oppose, right? All of the words in litigation are set up to be adversarial, right? It's not set up to be, right? I call them opposing parties. It's not necessarily that we're opposing, it's the other party, right? And so it's a commitment to keep that, hey, we're not going to burn this to the ground. We might not get along. We might not agree on how, if we agreed so much, we'd be able to do the kitchen table approach, right? We wouldn't necessarily need these attorneys involved in these meetings because we could sit down at a kitchen table and have an attorney draw it up for us. So we don't necessarily get along smoothly. There's not necessarily no emotions, but we're willing to work through those emotions as a team. Do you want to go to the next slide? Okay, so let me go back. Okay, so let me go back to the go back one more for me, the initial meeting. So both of you have to hire collaborative law trained attorneys is my reference. And then if both people agree to hire them, then we sit down as a team, all four of us, whether it's in person. There's attorneys who say, hey, in person is just much more better than screen. Some people say, hey, if we all live across the city, state, whatever, let's just do it on Zoom, work schedules, kids, all the things. So during that first joint session, Cindy, am I able to screen share? Or is that going to mess you up?
I mean, I don't
Oh,
mind.
it says I can't. It's okay.
Okay.
So the first joint meeting is where everybody is together, which is very uncommon, right? Like I usually don't get to talk as an attorney. If it's not a collaborative law approach, I don't get to communicate with the other party. I can only communicate with their attorney. It is a rule of professional conduct. I could get disbarred for communicating with somebody. But in this sense, we all four get to meet together. So versus you hearing, well, my attorney said blah, blah, blah. Well, my attorney said da, 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 da. No, you heard exactly what I said because we were all in the same room. Right? So it's not this he said, she said, it's we're all in the same room. And if you misunderstood what I said, let's clear it up now. Right? Like, so it's very direct. It's not like, well, what did they mean by that? It's you get to ask me, the other party gets to ask me in real time. I'm in the room like, hey, Sarah, when you said blah, 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 what did you mean by that? Right? And I get to answer. And my client gets to hear my answer. Right? That's not common. And it's a very different, unique approach. So we all sit together. We address anything that needs to be addressed right away. Does somebody need to move out? Does somebody need money? Is there something going on with the kids that we need to figure out right away? And then we all go over what are the high level goals of each of the people, right? Not positions. I want the house. I want the kids. It's what are your goals? Not positions, goals. I want the kids to have stability. I want us to be able to sit at a soccer game together. I want financial security, right? Like I know that my spouse hasn't worked or whatever, and I earn more, I earn less. It is talking about what are your high level goals, right? And oftentimes what we find is when we write those down, both of the parties have the same goals. It's how do we then get there? And then we go over the participation agreement, right? What the participation agreement says is, hey, anything that occurs during this space, this cone, box, whatever you want to call it, is confidential. It says neither one of you is going to go to court. And in fact, if the collaborative law process fails and you want out, neither side can file anything with the court for 30 days. So there's a 30-day cool down period. So if one party says, look, collaborative process isn't working for me anymore at session 2, I hate it, I want out. They can't file anything with the court unless it's an emergency domestic violence stuff for 30 days. So now both parties have 30 days to go find a lawyer, a different lawyer that does litigation, 30 days to figure out, okay, what am I going to do? Right? There's a cool down period. It's not you're getting hit with emotion, right? In litigation, you could, for example, literally, I had a case on Friday, parties still live together. Wife said, hey, I want a divorce. Husband was taken aback by that back in around the holidays. He says, hey, I think she's meeting with a collaborative law attorney. I want to meet with you. He's like, hey, I think we're doing collaborative law. Well, on Valentine's Day, I got an email on Friday last week where wife had filed for divorce, right? Which isn't uncommon in my world. Was very uncommon for him because he thought they were doing collaborative law. And it came in Friday afternoon. I didn't get it to him. Monday was a holiday till Tuesday morning. He's now on a trip with their kid, right? Mm-hmm. So he's like, I feel, and most attorneys this week, based on my experience, are all out with their kids because it's midwinter break. And so every email I'm sending to attorneys is like, hey, I'm out of the office this week. Hey, I'm out of the office this week. So now I'm like, hey, and I'm not doing litigation. So right, he's now scrambling to find, right? And that was the approach she took. And so that is versus when something's going to, everybody is very well aware in collaborative law and nobody can file a motion, right? So even if they're filing divorce, anybody can serve somebody with a motion you've got 14 days notice that I'm asking you to move out. You got 14 days notice that I want 100% of the kids. You got 14 days notice that I want $2,000 in child support. And you better respond, right? Gather all these financial documents, meet with your attorney, keep your full-time job, act like nothing's happening to the kids, right? And see you in court in 14 days. That doesn't happen in collaborative law, right? And I get that not everybody is fit for collaborative law, but in collaborative law, we're talking through things. If something arises that needs to be addressed, there's a team of people to address it, right? It doesn't mean that there's not high conflict. It means that the conflict is addressed directly and managed with a team, because we know is unaddressed conflict only then exacerbates other issues and other tensions, right? And so, that's the first meeting. Everybody signs a collaborative law agreement, and also at that first meeting, we decide who is going to be the team, right? Are we bringing in a financial person? Are we bringing in a parenting coach? Yep, perfect. Thank you, Sydney. So the collaborative at the first meeting, we may not need all these people on the screen, but we decide what is your guys' budget? Who can we afford to hire? Who do we really need? Right? So if there's no kids, we don't need a child specialist, right? Sometimes the coach can serve as a coach for the kids and a coach to manage emotions, right? Because again, us attorneys, nor are the judges trained in, most judges, I shouldn't speak for all judges, most attorneys or judges do not have a degree in psychology, right? We're not mental health professionals. We know a lot about mental health because we deal with emotions, but we're not. We also don't have a degree in childhood development, right? So bringing in a coach who is sometimes, or a coach that just has experience, like Sydney, right? Like exes and babies, meeting down. And so sometimes as attorneys will send, whether it's even in my litigation cases, if they relatively get along, I'll say, hey, what do you guys think about meeting with a parenting coach? So bringing in some of those collaborative law tools into the litigation and saying, hey, us attorneys, instead of us fighting over the kids, why don't you guys sit down with a coach, a parenting coach, and see if that works? And sometimes they meet for a 2-hour session and they both hate it. And sometimes they're like, hey, we're going to continue to meet with them. They come up with a back of the napkin agreement that now us attorneys turn into a court document, right? But now you're not paying us to do it. You're paying the other professionals, but those are the professionals. Those are the people that actually have the tools and can say like, yeah, I don't think like, and every child is different, right? So sometimes 50-50 or full custody for one parent isn't always best for kids. Different kids have different needs. Some kids need one home base. Some kids transition perfectly fine. But working with a mental health professional to also help manage the emotions, right? Because us attorneys are not trained in that. Financial specialists, although I know a lot about money because I deal with people's money on a daily basis, I'm not a financial specialist. I don't have any official training, right? And so we bring in a CPA or a CFA to you guys, instead of us paying an attorney to gather all the documents, exchange the documents, which is in your typical divorce, right? So you each go gather documents, spend hours doing that. Then you pay the attorneys to exchange them. And then each attorney creates their own spreadsheet. And now we argue over the numbers. Oh, you forgot that account. You use that value. No, we hire the financial specialist. So it can't be like, well, your attorney prepared that spreadsheet. I don't trust it. No, the financial specialist, that's the neutral team member. You guys worked with them and didn't pay us attorneys to do it, right? And they're well-versed in being able to pick up tax implications, right? Hey, if we divide this versus that, this is pre-tax, post-tax. Like I know some of this, right? This is the person that actually, this is their job. This is what they know, right? And so picking out what does the team look like during that first meeting and who do we need to get on board?
Hey, Sarah,
Yes.
regarding going back to child specialists, one of the things I witnessed watching like a really bad divorce, was, whenever a specialist, like a child specialist was brought in, there was the fear of like, okay, they're going to see I'm a flawed human. I'm not the best parent in the whole world. Like, am I going to lose my kids because I didn't give them matching socks to go to their dad's house? Like, what is the energy or what is the child specialist looking for? Are they looking to see who's the best fit parent and influenced custody, or how does that work?
Not in a collaborative law realm, right? Yes, in a traditional, if they're serving as a guardian ad litem or parenting evaluator, they're searching for, they're supposed to be, whether they do is what is in the best interest. So getting to know both of the parents, what their strengths and weaknesses are, getting to know the kids to the extent they can, and deciding what is going to be in the best interest of those children based on the information they gather. The child specialist in a collaborative law realm is gathering some similar information. They don't usually meet with the kids, but they are meeting with the parents and figuring out, Mom, what are your concerns? Why do you not want to agree for dad to be primary parent or 50% parent or whatever it is, right? What are your concerns, and then how do we then navigate those concerns? What would help you feel more at ease, right? And in versus an attorney sending a letter to say, hey, I don't like it at dad's house because he doesn't sit down and he doesn't feed them exactly at 6 o'clock. He doesn't feed them peas and carrots. He lets them stay up late. He is too strict with homework. He doesn't let friends tonight, right? And me sending some letter that's inflammatory or a court filing that is public, that the court kids can go back and read at any point that they want, but it's all public. We're talking about this in a cone of silence, and I can be honest with you, right? And sometimes I get a parent that's like, look, I really think mom or dad sucks at this, but I don't want to say that on a court pleading. But I would really like them to work on that, right? This is an opportunity to say that with the child specialist, to lay it out with parameters and not in a disrespectful way, right? And say, hey, I'd really like, it doesn't mean you have to agree, but now you understand more where they're coming from and feel versus like, I don't understand why he or she is fighting so much. He or she knows I'm a good parent. Why would they do this? And with the child specialist, with a third party neutral, you get to like help figure out what that is. And the child specialist also gets to talk about like, hey, it sounds like your kid is struggling with anxiety. So although mom or dad, I know you want 50-50 or primary, do you think that's best? Is that only going to exacerbate this child's anxiety? Hey, this kid has ADD, ADHD. Can we both agree? Like somebody put in the chat, like parallel parenting versus co-parenting, right? And so, parents are different, right? But I think you know, if you guys were together, that you parent differently. So you know your house is going to necessarily be different, but making sure that some of those tools from the other household are coming into your house, right? So that the child doesn't have two totally different experiences at two totally different houses. Going from one house, I'm not a mental health professional, so I don't know what the data is, but I fail to believe, at least for me, as a kid, going to one house where there's a lot of structure and I've got chores and I know it's expected of me, and going to another house where I can watch Netflix as long as I want, stay out as late as I want, dinner is not made, I'm just supposed to open up the freezer. Like that is to expect a child to go half the time to two totally different houses with two totally different structures, probably not going to work. So child support is supposed to help you guys come up with what tools, even though dad or mom, that you're going to have to make a deliberate effort, it's not your second nature to do, are you going to bring that, you know, goes on in the other house and vice versa. So the kid doesn't have two traumatically different households, right? But that is essentially like the child specialist serving. They help come up with what do those plans look like, right? And how, and sometimes I have clients who went through either of the processes who agree to meet twice a year with a parenting coach once those attorneys are gone, right? Just as check-ins. And sometimes they say, hey, everything's going well. I don't think we need to pay this person $300 an hour or whatever it is. Our insurance doesn't cover it. To me, another say, yes, let's do a twice yearly check-in. Hey, I've got this big family reunion coming up. Hey, Johnny's going into high school. Here's kind of what I'm thinking it should be his classes that he takes. Are we on board with that? He's gotten better at basketball. Are we really going to sign up for this select team that's going to cause both of us to travel? What is your work? Hey, I might get this promotion at work that's going to cause me to travel. Is that something you'd be able to help out with more with the kids? Right? I just don't, in litigation, that doesn't happen. Those conversations don't happen. And so then it's just, oh, I learned he or she was on a work trip and our kids at the neighbor's house, right? And now there's like this fight, all of the things, right? And so I don't know if I answered your question, Sydney.
Oh, you did. Thank you. Appreciate it. Appreciate it. Again, if you have questions, please put them in the chat.
So the first meeting, so signing a participation agreement, we kind of talked about that. It's a long document. In certain cases, we pull things out, add things. If I will say, if collaborative law fails, if you guys are not able to reach an agreement, it is required that both parties get two new, totally different attorneys. The attorneys are not allowed to serve because it has been this very transparent, very open process. And so you both have to go get new attorneys. So some people say one of the, I guess, downsides that people say is, well, now you've got to start from scratch because everything that occurred, unless it was signed, stays in that cone. You don't get to bring anything out. You don't get to use it against them in the litigation if it fails, right? So you're starting, it can be like repaying an attorney all over again. At the same time, a very small percentage of cases in collaborative law fail, right? But that's why knowing, are you really going to be open and honest? Do you think your other side's going to be open? Do you guys really think you guys can work through this with some parameters? Then very few of those cases, and the attorneys in those cases know, hey, these persons paid me and nobody's going to do collaborative law if all of our cases fail, right? So the attorneys and the team are very committed to making it work and trying all the tools and tricks before we throw in the towel.
Awesome. I see a hand raised. If are you able to put your question or comment in the chat for now? If not, then let me know.
Also, the participation agreement, again, it said, like Cindy said, neither one of you are allowed to threaten. And sometimes I have to remind clients in these meetings, it's like, well, if you don't do this, and I might as well just go to court. Well, it doesn't seem like
Sorry,
he or
Sydney.
she's moving, so I'm going to go to court.
It's hard
We
to
don't
put
mention the
things in the
word.
chat because I can't type because I have
That's why I was like, let me actually, yeah, thank you.
yeah, because I have a paralyzed left arm
Okay,
from my stroke, so I cannot do that very well. So I
okay.
apologize for that.
No, don't apologize. If you could
Okay.
just hold your question,
Yeah.
and I'll call on you soon. Thank
Okay.
you.
Okay. Yeah, that's fine. No
Thank you so
problem.
much for that context.
Yeah.
Go ahead, Sarah. Did you want to finish what you're
Yeah,
saying?
I think I was just saying that like you're not supposed to make threats, right? Or positions.
Mhm.
And so it is, you also don't have somebody threatening you. We have like just parameters about, hey, everybody's gonna be respectful. We're both agreeing to be fully transparent. We're
Mhm.
both agreeing that we're going to exchange financial documents. We're not going to hide assets, right? Like,
Mhm.
why pay an attorney to subpoena and do formal discovery, right? It's all very expensive when you're going to have to give up the information anyways, right? And so it is, the participation agreement outlines what is expected of the attorneys and what is expected of both parties in the process. So everybody knows what they're getting into at the outset.
Awesome. Thank you. Yeah, let's take a few minutes for questions. Go
Yeah,
ahead.
just had a question, and like I said, it's all new to me and scares the hell out of me. But my question is, like, let's say, I think the collateral law is very interesting, and my question is, like, let's say you come to a settlement, what happens if it's not executed on the one party, on the mother side? Maybe, what happen? How do you facilitate the execution? Let it be whatever the settlement is financially, or whatever the agreement is for the children, and let's say it was a coaching thing, whatever the case might be. Like, how do you force them, or don't force them? How do you execute that settlement? And if they don't do it, what happens in the state of Washington? Let's just say it's a financial thing. I'm supposed to agree to get half of whatever the settlement is, let's just say, hypothetically, and they're like, well, I can't do that. What happens?
Thank you.
And that
Yeah,
could be true for the parenting plan too, you know what I mean? Because I don't have a home anymore, because I'm disabled and stuff like that. And I could agree to, I'm pretty flexible. I could agree to seeing the kids at her house. I don't care. It's about staying connected with my kids. That's the biggest thing. So
Thank you.
let's just say, hey, you know what? This parenting plan, I cannot do this because I don't want you to come to the house anymore, for example. In those type of situations, let it be kids planning, settlement, or it could be financial. Like, what kind of recourse do you have as a parent if those things don't happen? Besides, like you're saying, they pay the attorneys to do the discovery work. Let's not let's not hide the assets or whatever the case might be. You know what I mean?
Right.
It's
Yeah,
just
so in cases where an agreement has been assuming that it is, right? Like some of my clients will
yeah,
meet at a kitchen table and say, hey, we sent an email as an agreement. Ideally, it would be signed, oftentimes notarized,
right.
to make it an official agreement, right? And enforceable in court. It also should say that it's enforceable by a court. In collaborative law, at the end, we then do start to get you officially divorced, or to make it we then do present it, but everybody's presenting it collectively together. And so in King County, for example, you don't have to appear in person. Your attorney uploads it, the court looks at it, signs off on it, and you're done. But that's at the end of the case, and everybody knows it's coming. In a traditional litigation, if you then reach a settlement that is binding, it is also then presented and it incorporated into the final documents that become court enforceable. As a part of either of those processes, the parenting plan has a section called dispute resolution, because inevitably disputes are going to arise with regard to parenting, even no matter how good you co-parent, there's going to be a dispute. I want him to take chemistry. I want him to take dance. Okay, we're disagreeing on the elective. Now, can we work through this, right? So we ask the parents early on with the parenting plan, if a dispute arises, do you feel comfortable going to a counselor, a parenting coach? Do you want a mediator? Should we name that mediator now, or a couple of them in case they retire? Or do you want to go to court? How do you want to resolve a conflict? Because we know with parenting, a conflict is going to arise. And if when it does, how do you want to resolve? So those are already embedded into a parenting plan. And if somebody doesn't follow it, you can file a motion for contempt, right? We're talking more litigation there, so I'm going to try to stay away too much of that topic. Similarly, if you have a binding agreement with finances, you could put in with a collaborative law agreement, okay, if a dispute arises, are we arbitrating? Are we mediating? Like, hey, you said you're going to pay me $5,000, or you're going to move out of the house by this day. You haven't done that. In the collaborative law process, we often try to come back and figure out why did it, assuming everyone wants to come back, why did this fall apart? But otherwise, both sides are either able to arbitrate it or bring it to court and ask the court to enforce a contract that has not been followed. At that point, it's kind of contract. It's still family law, but it's somebody hasn't followed a contract.
Yeah.
Okay, Sydney, do you want to, okay, so signing participation agreement, you want to go to the next slide? Thank you. So information and gathering, that's what we talked about with the financial person, right? So during the second meeting, we start like, so after the first meeting, we send everybody off to either go get your parenting coach, get them on board, give everybody some names. We send them off to a financial person. The financial person is going to give them their homework, right? So after every meeting, and again, these meetings are 2 hours, right? We break it down. And so most cases, we try to do no more than 5 meetings because it becomes costly. But some clients need more meetings and some need less meetings. But we send everybody off to do homework. And so long as what I tell clients is in this process of that chart we saw at the beginning, you guys are in the driver's seat. I'm not the driver. So you have homework after that meeting. We send out notes so everybody knows what their homework is. And you're expected to do your homework before the next meeting. Otherwise, it's a waste of everybody's time and money, right? And if we need to postpone the meeting, fine. But right, you're going to irritate somebody. So everybody's trying to be on board. And we try to, again, 2 to 3 weeks in between meetings. So it's not too long, but it gives everybody time to do their homework and decompress and get ready for the next meeting. So in the next meeting, we usually talk with the financial person over what are the assets, what do they look like, start talking about budgeting, and start talking about the financials piece. Third meeting is we start articulating elements of the settlement and starting to get into more positional things. The fourth meeting, again, just depending on bringing in coaches, right? And some of these meetings don't have to necessarily go in order. Everybody's different. We decide, right? That's the great part about collaborative law. Hey, I don't want to talk about finances first. I really want to focus on kids first, right? Figuring out what needs to be addressed, and in which order, right? Then are we bringing in this parenting coach? Were you guys able to come to an agreement on your own? Or are we talking about parenting in one of these meetings, right? And so it's not this 8-hour, again, 8+ hour drawn out. We're talking about everything in the kitchen sink. We're breaking things down, and in between, every meeting has an agenda, right? Everybody gets the agenda before it goes out. Each attorney meets with their attorney before the agenda goes out and says, hey, Sally, John, Sydney, is there something that has come up? Yeah. You know, he's been 30 minutes late to every drop-off pickup. I'd like to discuss that during this upcoming meeting. Hey, she's not letting me blah, blah, blah with the kids, right? When I have the kids, she's calling every 5 minutes, so it interrupts our time, right? So what things have been going on that we need to discuss, but also how do we keep this case moving, right? Instead of blaming and shaming, how do we talk about, okay, like the relationship is over, right? And that's why sometimes the parenting is over. There's a reason why you guys are getting divorced. And some of those reasons are going to still seep into either litigation or the collaborative law, right? The things that irritated you about your spouse then are going to continue to irritate you. But it's navigating those and managing them. And so gathering information that we need to be able for everybody to be able to make a knowledgeable and fully informed decision. Hey, if we live in Seattle and now one party is wanting to move to Tacoma, I kind of need to know that when we're putting together a plan. Where are you thinking about moving? Can we agree to move within a certain amount of miles of each other, right? Like, so information gathering is important. And unlike litigation where we're demanding documents and doing it in a variety of different ways that can be costly, in collaborative law, it's like, hey, I need this document, you need to get it to me. Right. And so it's just more, I think, a smoother process in that instance. I'm ready. Okay. Identifying goals and interests. I think we've kind of talked about this. Like the very first meeting, we're doing those high level goals. We're having everybody write them down. It used to be that we have a piece of paper and we write them down on, right? And now we're doing it in a chat in real time where we share our screen and do it on Word. But writing down everybody's goals so everybody knows, right? Like, and you're supposed to be fully transparent. What are he or she's goals? Now you both know versus like, I don't know what the other side wants. I'm left in the dark. We're talking through the attorneys. And so I think that's very also important. And sometimes it's hard for clients to articulate what their goals are, right? And what their needs are. And so that's what I think having a coach involved, having a collaborative law process to be like, you said you wanted the house, but what does that mean? Is that you don't want to, why do you want that? You're getting to the why. Why do you want the house? Well, because it's meaningful to me. It's got a low interest rate. I really don't want to move the kids. The kids have grown up in this house, right? My parents live down the street. It's getting to the why. And I think that the why to me is very important in a divorce, and you don't get to know the why necessarily in a litigation. It appears to the other person that they're just fighting to fight when sometimes they have a reason why.
This is my favorite part.
Exploring options and developing solutions. What is your favorite part about this?
Developing solutions, because as I learn more about collaborative divorce, that's where that creative part is. So identifying the goals and the why can allow for you guys to do more creative solution seeking versus like when you're in the courthouse, you can't be as creative. You guys have more control in the collaborative divorce, which I think is so powerful. It's like, hey, actually, we're going to do like this kind of schedule, or when they're this age, we'll do this. And you really get to decide what that is for yourselves together versus the court. Maybe they're only used to seeing one kind of breakdown of parenting plans or a few, and they're not open-minded because they're like, oh, that doesn't make sense. But I don't know. I like the creativity that can be allowed here
I
and
think that's huge.
personalizing it. Yeah.
Yeah, I think that that's huge. I think like to give some example, like it's the court, as somebody pointed out, like, look, you got 5 minutes to argue your case. The court's not even reading your documents, right? They're like cookie cutter, get out, right? And not that they have a ton of cases before them, and I don't agree with the way the justice is set up, but that's kind of how it is set. Like, I have a lot of grace for the court because I do think that they're put in a tough position. And so I think that the collaborative law method allows both of you to throw out an idea that the other side may not have otherwise accepted it, right? Like, again, when I went back to someone like, well, hey, I want to propose this. And I'm like, are you sure? Right? They get to do that in the same room as somebody and say, hey, and they can say, oh, that might not be a bad idea. A small example is in Washington State, the courts cannot order that parties share animals. They're viewed as chattel. So if you guys have a dog that you both really, really love, the court has to award that dog to one party or the other, right? California law, other states have different laws. Washington cannot. Even if the judge thinks you're both really good, very close relationship with this dog, the judge's hands are tied by the law, right? So sometimes when you go to court, the judge's hands are even tied. We're talking about out of control, like everybody's letting go of the steering wheel. It's the judge has to make the decision. In collaborative law or an agreement, you guys can agree to, hey, the dog travels with the kids, or the opposite. When I got the kids, you get the dog. You guys can agree to things that the court may not necessarily be able to even allow, right? And so coming up with creative solutions that you aren't going to get in court because the court literally cannot allow it, I think are important. And so I think that that's also a good benefit of it. Negotiating and settlement, I think we've talked about like shared goals, helping getting all the data. Now that we have all the data and nobody had to like kick and scream to get the data, right? And it didn't spot like you started with divorce. I'm still like my head is still spinning. We've slowed down. We're breaking this down into 2-hour sessions so everybody can digest what has occurred and prepare for the next meeting. Go meet with their private therapist, their village, whoever in between these meetings to make and checking with their attorneys to make sure that they still have the support that they need. And coming up with what they think is fair, right? It may not be what the law is, but it's what you guys both feel is fair and have the knowledge of it. Also, what I think the gentleman that asked the question of what do you do when somebody doesn't follow the agreement? I'm not going to say that people don't follow agreements, but the data does show that being court ordered to do something versus you agreed to it, people are more apt to follow it. So contracts where either through the shuttle diplomacy mediation or the collaborative law method, if the two or the kitchen, pretty much everything but the trial, anything but telling you what to do, people are more apt to follow it. And you get less violations when the parties came to a mutual agreement. Not always, but it's more apt to be followed because you decided it versus being told what to do.
Now, Sarah, this whole idea of fair is subjective, is it not? Like,
Is
how,
it?
what do you do? And like, well, this is fair. Well, they both have great points on what's fair, but it's not the same. What do you guys do in those situations?
Yeah, helping parties like, why do you feel this is fair, right? And why do you think this is unfair, right? Like he or she's asking for X. They want every Saturday with the kids. And they said that's because their mother comes into town from Spokane every Saturday. Is that fair or unfair, right? And talking about it, right? Again, some parents may say, yeah, I'm fine with mom getting every Saturday because I've got work every Saturday. Another may say, hey, that's not fair. A lot of things go down on Saturdays, fairs, festivals, museums, things of that nature are open on Saturdays. I also want to be able to do some of these things with the kids on Saturdays. Okay, can we reach some sort of agreement, right? Where maybe mom gets a lot of the Saturdays, but not all of them. Is grandma cool with everybody? Can grandma go to dad's? Can grandma still see the kids at dad's house? Right? Like things that the court doesn't, not that they don't care, that they don't have the time for. And I'm not saying that I agree with the way the court system is structured, but again, they're not thinking those through, right? So I think you're right that fair, and that's another reason why I encourage clients not to go to court, because it says what's fair and equitable. And every single judge up there may have a different definition of what is fair and equitable if they were presented with the same facts.
And last step.
Implementation moving forward. I think, again, keeping open lines of communication once us attorneys are out of it. Managing, how do you guys communicate? Are you guys sending each other text messages daily? Right? Trying to, like, I've got some cases where they're sending 1,000 messages in one day. Can you wrap all that together in one email, maybe? Right? Giving the other side grace. Looking over your agreement from time to time to see what needs to change, what's working, what's not working. We can put stuff down on paper. Kids change, right? Yesterday, my kid loved hot dogs. So I say, Dad and I must feed child hot dogs. Next day, kid hates hot dogs. Doesn't work. And now we got a quarter that says hot dogs, right? So being able to be flexible with not just, oh, this is the court order, this is what it says. But you have to have that relationship to be able to do that, right? And continuous communication, not just communication when you want something, right? It's got to be a two-way street. And I think who you hire, I think we may have maybe missed this, like interviewing attorneys on, hey, how often do you go to court, right? If you get an attorney that says, I love going to trial, right? Not am I good at it, but I love it. Are they going to push your case to trial, right? Asking them, do you do everything in your power to try to settle cases? How often are you in court, right? And sometimes out of attorney's control, right? In any given year, I might go to trial once. I might go to trial 3 times. Is that me? Is it the cases that I dealt with? I think knowing that, because do you have an attorney that is just not willing to sort through the issues and rather just have a judge decide? Because that's how they're wired. Doesn't make them wrong, it's just how they're wired. Do you have an attorney that's good at communication and is going to help you with your communication and help counsel you with, hey, is this really the fight you want to have? Is this the bone you really want to pick? Right? And figuring out, right? There's a difference between, like, I think there's a fine line between us attorneys having empathy with our clients' emotions and also helping them manage those emotions and checking them, versus helping them de-escalate versus escalate issues. He or she brought the kid home late. He or she brought, oh, let's go to court. I'm going to file this motion versus, okay, can I send them a letter first and ask them, hey, you've been 30 minutes late for every drop off or pickup, mom. What's going on? Should we move the schedule? Do you pick the kids up 30 minutes earlier, right? Like communications. I think interviewing your attorneys, deciding, knowing who you're hiring and what is their reputation, asking them, but also doing the research, I think is very important. I also think it's very important to interview at least 2 attorneys before deciding who to go with, because we all have different ways of how we approach things. And so you want to make sure that somebody's going to approach issues the way you want them approached, right? Some people they want to fight, they want to, for whatever reason, they're high emotional strong, and so they hire that hired gun attorney so that they don't have to be the ones that communicate, right? And I'm not saying that's the wrong way, What happens when that attorney's not there anymore? Right? We're in your life for maybe a year. Some people have like horror stories of 2-3 years, right? But you guys have to continue to show up at parent teacher conferences, soccer games, weddings, birthdays, still. And how are you guys then going to act when the attorney's no longer there? So having an attorney that's going to not completely burn it down to the ground, and somebody that you also aren't going to just burn it to the ground. Okay. Do we still have more
Yeah.
slides?
So,
Sydney, can I pop in here for a quick sec?
yes, please.
This
I'm
is
gonna
hard
stop
to
sharing
do
my
'cause-
screen so I can pull something up really quickly. Go for it.
Yeah. So yeah, you may have that video or more content, but I just wanted to encourage people to fill out the evaluation while they're listening to the rest of the session, because we have a chance to hear back from you both around this presentation, but other things that you would like to see. And then can I posit a question here too, as you're kind of winding down, about many folks in this room and in the conversations that we have with fathers end up in court unrepresented. And I get it that this is a process that, you know, you are, both parents have representation and they have resources to hire these additional professionals. So this is maybe a difficult question, but I'm gonna see any ways that you can draw out some thoughts or suggestions about how do you incorporate some of these principles and this work if you're going into this process without an attorney.
Cindy, do you want to go to the last, do you care if we go to the last slide real quick? One, maybe starting there. It was the slide on King County Collaborative. I think it's the last slide, maybe it's not. Sorry. So to start answering the question, the City's gonna go on one slide, so this doesn't directly answer the question because this is still with attorneys. But there's, oh, is that the last one?
What's the
We
slide?
had-
You want this one? Oh, this one.
No, so King County Collaborative Law has, and there's the website, has a sliding scale, a low bono option, right? Where both parties have to earn under 124,000 a year. The total household in assets, excluding the house, has to be under $30,000. I actually literally just got an email this week about getting appointed to one of these. And so a lot of us attorneys are signing up to do these, right? We can't do a ton of them because I still have to pay my bills, but I try to sign up to do either a low bono or pro bono case, 1 or 2 a year, right? To give back. And I enjoy it. And there are other low bono options out there. April Thomas, other attorneys, if you go on King County Bar Association's website, they also have attorneys that do low bono or pro bono work. And so there are some resources out there to try to get counsel. Another option is some attorneys are willing to meet with clients on the side, right? Sorry, Cindy, when you go back to the very first slide with the diagram of the different options, I think it's like a
Okay.
sorry. Thank you. Okay, so this one, right? Like the kitchen table, can you sit down and like, even if you guys have filed or somebody's filed, is it safe? And is this person willing to sit down with you at a cafe? Hey, you're spending a bunch of money on attorney's fees. I'm spending a bunch of money. I can't even afford an attorney. This could be money that I could be, and I talk clients that sometimes. Like, look, you're paying me to ask for child support, mom, potentially, right? And here's what I think it could be. He or she's offered Y. You're going to pay more in that in attorney fees and trial. All of that child support or whatever is going to be eaten up in attorney fees. Can we reach an agreement? Yes, if we went to court, you might get $50 more a month, but let's do the math on that $50 when my hourly rate is $375. Right? And so those are conversations I have with all of my, I don't care what your gender is. That's often if we're arguing over a microwave. I can go to Target and buy you the microwave right now. Right? Like it's not like what is worth it. And I get some things are sentimental, right? And I guess it's not like, are you foregoing what you're entitled to versus the law versus, again, we talked about emotions, right? Yes, you might get $50 more a month, or you may pay $50 less a month in child support if we go to court. But what is the emotional strain for you, whether you're represented or not? The time and the energy, the unknown, right? So sometimes you're paying or you're settling on something because it's emotionally better for you or the kids. but still trying like versus fighting. Another option is the second one, mediation. Again, those mediators, instead of paying an attorney to be present in the room, you guys are still sitting down with a third party neutral. And some of the attorneys, some of them do low bono work through King County. Some still charge anywhere between $250 to $500 an hour, right? But you're then not paying for an attorney. And that way you still have a third party neutral in the room, with or without an attorney, right? And so those are different ways of doing things, and those mediation sessions, still agreeing to break it down into 2-hour sessions, 3-hour sessions, whatever works for the two of you, but coming fully prepared. I would say that's one thing that I sometimes see from pro se parties, whether they're on the other side or whether they're hiring me to advise them behind the scenes. They come to me and say, hey, I'm hiring because I want you to, he or she offered me this. Is that fair? And I say, I can't tell you what's fair. Well, what is the court going to say? I can give you a range, right? But there's a range of what I tell clients, look, I need you to sit down and do the work. Have you thought about what you want? Do you like this proposal? Yes or no, and why not? What are your concerns? Does this meet your high level goals? And if not, what do we need to adjust it to make it fit those? And so there's different ways, I think, and I don't know if I answered your question about the proposal, but there's other family court services they've got family law facilitators that are supposed to help fill out documents. Some people find them helpful, some people don't. King County has most of the counties, whether it's Snohomish, Pierce. If you look at their online resources, they have where I volunteer a couple times a month at a library, or it's usually once a month for me, where people bring in their documents, try to fill them out as much as you can, right? And then that way I can sit down and look over them and say, hey, I think you should word this differently. Hey, I think you didn't fill this out. Here's what the court's looking for, right? And so you get free time with an attorney, and you can go to those sessions as many times as you want. They usually only give you 30 minutes to an hour, depending on which clinic it is. So coming fully prepared as possible with questions is going to get you your not a waste of your time, right? And allow that attorney to focus on your case the best and what they can do to help you. Another option is most counties have a law library at their courthouses. And those law librarians cannot give you legal advice, but they're usually very knowledgeable. And they have got videos, they've got pamphlets, a lot of the things. I would say sometimes AI is helpful, but usually what you first Google, right? AI is only as good as the information you put in. So if you're like, well, I want full custody of my kid and I'm a great father, it's going to spit out, you're it. But you've also got to be honest with yourself. What are they going to say are your weaknesses? What is mom's strengths? Ask. I wouldn't completely rely upon AI, but there are a lot of good things on a lot of law firms' websites. A lot of these coaches, these collaborative law coaches, have tools on there. Sydney's website has podcasts. She's got resources on her website to help. How do you navigate a difficult parent? How do you navigate a narcissistic parent, right? So sometimes the work is just with you. So there's a lot of resources out there, books, but you got to be careful of the source. And does that apply to your case? Because everybody's cases are very different.
Awesome.
Another way of
We'll
with Sydney, sorry.
Oh, sorry, we just have a few more minutes left.
Yeah, go ahead.
We can send out an email with resources. And what do you have something you're going to say?
Yeah, sorry, this is really hard to do without a camera. I feel like I'm just trying to show you body language, but I can't because I can't. I'm here. Yeah, Zachary, if you could pop your question into chat, I think we're gonna run out of time here, and I appreciate that you've got another thought to share, so we might be able to get to that. But thank you, Sarah, because I think there's lots of concepts of collaborative law that people could use in an unrepresented situation. And we just hear so frequently from parents that, yeah, the kitchen table, the cafe, we had it all figured out until we got into court and we got lawyered up, and then it all went south. And so I think that that's part of, the takeaway that I'm hearing from you all is there are concepts here that are really helpful for you in many different types of situations. If you are lucky enough to be able to be in a collaborative law process and have folks that are trained in healing and keeping families as healthy as possible when they come out the other end, that's the gold standard. But for some folks, that is not going to be accessible. But I love to hear that some of the counties are doing some supported time with attorneys. That's great. Because for some folks, I'm sure they're not even thinking that that's an option, because we don't often hear about that. So that's exciting. And then the court coordinators, I do also hear from different counties about how difficult it is to interact with them, because that's a county funding decision and they often don't have enough capacity, right? So, folks in different places that have resources are really thin on the ground, right?
Yes.
So
Sorry,
thank you.
we only have a few. Sorry, I don't mean to interrupt, but I really want to just finish out these slides really quickly. We only have
Go
4
ahead.
minutes left. Hopefully you guys got that there's a lot of benefits to, I believe, fathers, and I would trust the fathers' input more, but unfortunately we couldn't find someone who'd gone through collaborative that was willing to share their story. But there's more control. There's more control that you have when you go through the collaborative process as a father, because of the philosophy and your lawyer encouraging you to be collaborative and cooperating. I think also another piece that I want to make sure we leave sharing is, who are some of the best candidates for collaborative? Those are folks who are willing to be cooperative, willing to compromise. There's not a huge power difference between the two parties, right? So
Yep.
no history of abuse or things
And
like
there
that.
can be, sorry, Sydney, we do
Oh, please, yeah.
screen for DV, because if there's a power imbalance, right, and somebody's just getting beat up on, but also those are the cases that after 1 or 2 sessions, the attorneys and the coach are going to notice that there's some power imbalance. We will do some sidebars, say, hey, he or she, you're not speaking, you're just getting railroaded. And it sounds like you're just acquiescing, right? Like that's why we have these mental health professionals that can pick up on body language and other things. And sometimes we say, hey, if we can't get this power imbalance right, we're going to need to terminate this process, because that's not the goal, is that somebody comes away beat up. But depending on what the DV is and the severity of it, and if both parties feel comfortable that they can advocate for themselves with a team in place, then we may be able to move forward with cases that have drug addiction, alcohol addiction, mental health, disabilities, prior domestic violence. But we do have to screen, because this is a very transparent, safe space. Sorry, keep going.
That's awesome. And then the next slide is really just the opposite. What would not be, what folks who might not be the best candidates for this type of service. And then, yeah, I was gonna share a quick video that I think just kind of brings it all together for me anyways, in terms of, can you all still see my screen?
Yep.
Okay. I have another collaborative divorce lawyer that I adore as well. Can you hear this?
Final session, they
Yep.
actually spent time just acknowledging their marriage,
Wow.
being grateful for their children, for the years that they had been together, and for the gifts that they had given each other during that time,
Wow.
and that it was time to move on. It was the first time as a lawyer that I was like holding back tears. I was like, I'm gonna cry right now, and I'm a lawyer. Like I'm
Right.
Really?
No feelings.
Save that for home.
I know exactly. But I was just like, oh my gosh. And they,
That's
you know,
beautiful.
and they gave the rings back, and it was just, yeah,
Oh,
it
wow,
was
sounds ceremonial.
it was almost ceremonial.
So I bring that up. She was referring to the last session of a collaborative divorce process, and how, they had such a healthy, I imagine, divorce that, it's almost ceremonial handing back the rings. It just gives me hope that, as people move into this next phase of their lives, as they're divorcing, that I hope and pray that collaborative divorce can allow them to honor the parts that were good about their relationship, and transition to this next phase with respect, and especially as co-parents now, still partnering together to parent. And so I know we're out of time. I know you all are very busy. Thank you, Sarah, for presenting and sharing
Thank you all.
Thank you, Sydney. What a lovely way to end this. Sarah, do you have a final thought you want to leave people with?
I think trying to figure out what really matters to you, what your goals are, but also trying to be understanding where the other side's coming from. and keeping the kids at the forefront of all of those decisions, which isn't always easy. And so sometimes it's coming back and being grounded in the middle of whether it's litigation or collaborative law. Sometimes you got to come sit back and say, okay, what was my goals again? So, and I think writing those all out early on. I also think one thing we didn't hit on is, although in a prenuptial agreement, right, or cohabitation agreements, right, can help, although they're not enforceable with regard to who's going to get the kids. I think having those conversations probably before you procreate with someone of, hey, if we don't work out, what are you thinking, right? Like, and people may say one thing to you and switch it up, but I think conversations aren't necessarily had. And so I think communication.
Thank you. So much love coming to you in the chat. So much appreciation. You two are amazing, and I wish everybody had access to your resources. And hopefully this is the direction that we're going, right? This is the goal that that we're moving toward, I hope, in our court systems and in the way that we help people set the stage for peaceful co-parenting. If, you know, how you end is how you begin, right, for the next stage. So thank you so much. Thanks everybody for doing the evaluation. It's in the chat, and you'll have another day or so to finish that up. And please come back and join us for the next session on sort of the journey into parenting for fathers around that sort of first 1,000 days period, and thinking about social emotional wellness in that couple and for fathers in the early part of that journey. It's such a critical topic that we don't talk about very much. And part of this was seeded by the changes in the law in our state that we can screen both parents for peripartum mood disorders because dads have challenges too. And so thank you for joining this 2-part series, and stay with us and come back and bring your energy to the next conversation. And just thank you so much to the two of you. And if you'd like to stick around, Dieter can go through the feedback that we have so far, if you've got a